This is the outline of my paper as such it is, the draft. And so the effort is to make kind of two main points, followed by some policy implications. And so the first point is that there is a connection between copyright fair use rights within copyright system, and we'll talk a little bit about what I mean by that, or what different people mean by that, and international human rights. That fair use rights are one of the ways that we promote both freedom of expression within our own constitution and freedom of expression, right to culture, education, et cetera, within the international human rights system. And in that part, and I may actually spend most of the talk kind of focusing on that, I want to introduce a bit of the layout of what it means to kind of make a human rights argument. What's, Human Rights Law 101, just to kind of give us some background. I have handed out the second version, which is that there's also a relationship between fair use and international economic law, that fair use rights promote trade and promote development. And so those two basic postulates, that fair use is related to human rights and fair use is related to trade, lead to the question, whether we should, and the answer is yes. And moving on to how should we promote fair use rights within the trade system. And mainly there, I'll assuming I have enough time to get to it, kind of show you where we've gone so far. And the paper itself will make some further recommendations about where I think we should actually go. So that's kind of the structure of the argument today. Let's see if this works. Point it there. So first, what do we mean by fair use? That term is actually very, you could say, contested, at least ambiguous. So in one sense, fair use means Section 107 of the US Copyright Act. Section 107 is relatively unique in using that term. The term fair use was first used in US copyright law, first in court decisions, later in the statute. The 1976 statute was the first statute to use that term. The clause itself is not as unique. It looks very much like general exceptions to copyright that are contained in most Commonwealth countries, most countries that derive their legal systems from the UK, although they're called fair dealing instead of fair use. And at least if you stop right there, I would argue there's no distinction between fair use and fair dealing just in those terms. That the terms use and the terms dealing mean exactly the same thing. And what they mean is any use. So that's different than, for instance, a quotation exception, which only applies to a certain kind of use, the kind of use of quoting an excerpt from another text. So it is open to any use. But again, as I mentioned, those aren't necessarily distinguishing aspects of US law. If you count all of the countries that use either fair dealing or fair use, there's 80-something countries around the world that have that degree of openness. And indeed, when I was doing a little research for this, I came across a YouTube video of a lawyer from Mayor Brown's UK office talking about defining the fair use rights in UK law. So she used the term fair use to describe a fair dealing statute. And she specifically mentioned the fair use rights that exist in the UK for criticizing other texts and for educational and other purposes. And that's actually the distinction between US fair use and UK fair dealing, which is that the US fair use right is actually open to any purpose. The magic words are such as. And the UK has a closed list. So in order to take advantage of the general clause to make any use in the UK, it has to fit a closed list of purposes. But as that example demonstrates, in common discourse, even among lawyers, the term fair use often means any right to use copyrighted material without authorization of the author. And so often when I go around the world and work with people working on copyright exceptions, they refer to those copyright exceptions as fair use rights, even though their statute doesn't say fair use, and in fact may not even have a general limitation exception. So I want to keep kind of referring back to those two definitions. So fair use as US fair use as any right to use copyrighted material without authorization of the author, and then a third definition, which is the one we use in our empirical work, which is there we say fair use means the first exception, any right to use copyrighted material without authorization of the author, that is more like the US Fair Use Clause in that the exception is open to any kind of use, open to any kind of the use of any kind of work, open to the use of any kind of work by any kind of user, and then for any purpose. And if you look at section 107, the fair use right is open in all of those aspects. Doesn't matter what kind of work is. Some exceptions only apply to literary artistic works. Some exceptions that I've seen for educational uses don't apply to audiovisual works. They don't give you the right to use or alter a movie in the classroom, for instance. Fair use would give you that right. Some rights only apply to certain kind of users. You have to be an educational institution, or you have to be a library itself in order to take advantage of that right. Fair use applies to the patron or anybody else as well. Many fair use rights don't apply to any kind of purpose. The UK that I just mentioned, you have to be one of these in a close list of purposes. Okay? But you can find that kind of openness throughout the world. South Africa's quotation example, for instance, which is not open to any kind of use, it's only open to the kind of use of quotation, is open along all of the other elements. You can use it for any purpose, you can use any work, any user can use it, and it turns on a balancing test that just calls it fair practice. But it's kind of like the US fair use right. So in that sense, and I might kind of use this term, I'm kind of playing it out, but I call it open, flexible, and general rights. And as a footnote, I'm going to kind of try this out. It's an OFG fair use. It's an actual fair use that incorporates all of the elements. Okay? So, definitions aside, why are we talking about this within a human rights lecture? So we can start with, and the Eldred case was already mentioned, but so the Eldred case is often used as the citation for the principle that fair use is part of the built-in free expression protections within the Copyright Act. So imagine a copyright law that didn't have any fair use in the first definition, no exceptions, only protections. Every copyrighted work is governed by the exclusive right of the author, full stop. You got to get permission to do everything. So imagine what that world would look like. How would you write a book review without quoting the book? How would you make a mashup video without being able to mash up other videos? From the classic to the modern uses, you can see how free expression would be dampened without the ability to use other works for some purpose. And so you need within the Copyright Act to promote the human right to free expression to start out with. You need exceptions to the exclusive control, or the right to free expression will be dampened. And that's, as I mentioned, built into our law. But it's not just free expression, right? And this is an incomplete catalog of applicable human rights, but we have international human rights to free expression. And you notice that those international human rights include not only the ability to impart information, but the ability to receive information. We often call this access within the IP community. The right to access other works, the right to make and access and use educational texts, and there's an international right to education, right? The the right to take part in cultural life, to produce culture, to be a creator, requires access to copyrighted works, but also to receive culture. How do we construct our system in which people can access the culture that's created? To enjoy the benefits of scientific progress, you know? How can you engage in scholarship if you can't access scientific journals, et cetera? So copyright and human rights can be in some tension unless you have these built-in human rights safeguards, which is that fair use definition number one, right? What do human rights require? So human rights, within human rights law, within human rights discourse, three kinds of duties that just help you kind of think about how to approach a particular human rights question. So the first one is states, and as I mentioned in a minute, also international organizations, are bound to respect human rights, which means they should not take affirmative state action that deprives people of their enjoyment to human rights. So this is what the Eldred case was about, right? So Congress makes the affirmative extension to add 20 years onto copyright. And so Larry Lessig brings the case into court and says, well, you're removing massive amounts of works from the public domain, so we have less of ability to both receive and impart information, which is part of our free expression right. So you need to meet a burden. You have to justify yourself, right? So the Eldred case came back and said, well, because of fair use, because we have this open, flexible exception, that free expression right is not necessarily hampered. We don't find a violation of the right to respect. But again, imagine where you could find such a case. On the panel before, I think Danielle mentioned, well, what if a country got rid of its fair use right? Well, I think you're starting to get, much closer to a violation of the duty to respect. Okay, the duty to protect. The duty to protect means states must take action within legislative and other measures to protect rights from other private parties. You need to have a regulatory structure. You need to have aspects of your law that makes sure that a private party can't hamper your rights. And so it's last night's lecture on Google and YouTube, right? So you have a content ID system that automatically takes down information from the public domain, if you will, in response to copyright violations. And the Lentz case says those private actors must consider fair use before they do the takedowns. So that's the judge as an organ of the state creating an action to protect the right to free expression by interpreting law in a certain way. And I think that's important to remember that our resources, our state resources to promote human rights include interpretation. Interpreting our existing laws in a way that promote rights, as the Lentz case did, is one of the tools that states have a duty to use in order to promote human rights. So as we go through a lot of these questions, you're thinking about human rights law, well, how does human rights law help us interpret that particular ambiguity? And then finally, it's the positive duty to fulfill. The state must take positive steps to promote the actualization of rights over time. And that duty continues. It's the progressive realization duty. You must move forward, right? And these duties, as I mentioned, apply not only to states, but to international organizations, to trade agreement negotiations. So trade agreement negotiations in themselves to follow human rights duties should be taking steps to promote the actualization of the right to culture and the right to education, the right to free expression, et cetera, which gets me, towards the part 3 of the paper of what should trade agreements do as part of the ways states act in the world today. Okay, so that's kind of laying out the human rights arguments. I'll swing through the economic arguments. But the arguments are essentially that the core purposes that we promote in international economic law are actually promoted by fair use rights as well. And so this is part of a published paper that you can find on SSRN. It just came out in December. But so we did an empirical project. We went out through our global user rights network, and we identified 20 different kinds of exceptions. Only one of them, the first one, general exception, is the most like fair use. So again, we looked at the openness of exceptions, whether or not they were specific to a specific kind of use or a specific purpose. And we did that in 21 countries, roughly divided between developing and developed countries. And we mapped them. And what we found is that if you look over time from 1970 to roughly the present, that all countries are moving towards more open exceptions. All countries are kind of realizing that at least in some of these different categories, that it's better for society to kind of apply to all different kinds of works or all different kind of uses, et cetera. You can imagine, reading, and you can find these in many countries, a law that was written in the 1970s or the 1960s or the 1950s that hasn't imagined the digital moment and what would be missing from that. And that's one of the key values of having openness, is you don't have to worry about the future. You can future-proof it by having more open exceptions. So an educational exception that says you can use any work for an educational purpose as long as it's consistent with fair practice is much more future-proof than you can make a mimeographic copy of one work for classroom use, which I believe it's almost exactly what Argentina says. That's all you can do. You can't email it. You can't post it on Blackboard. The only thing I can do is make a copy like I just did and bring it to you, right? And some laws literally say just that. But there's a gap, right? So the high-income countries are moving towards openness much more quickly than the developing countries. And that's our problem, right? So in today's age, many countries are ill-equipped to kind of move into the digital era from a lot of these public interest exceptions. And the second graph is kind of the same data, just showing you where the action is. And a lot of the action is over on the right side, traditional quotation, educational. Personal and private use is a very important modern exception because we're constantly making digital copies and transferring them from one thing to another, which you can't do if your private exception is not open. But there's less work around some of the key stuff in today's digital environment: transformative uses, text and data mining, computer programs, things like that. And in developing countries, completely inadequate. Not even addressing the concept, much less addressing it in an open way. So then the next thing we did is we gave all this data to our economists, and I am not one, so I won't take any of the hard questions here, and we did econometric analysis. We compared it to economic data over time, and we found that and we controlled it for factors like GDP per capita and firm size and things like that. None of it's going to be entirely perfect, but we tried as much as we possible to say, well, is there a correlation between having more open copyright environments and different kinds of economic effects? And what we find is that there is a positive effect on investment. So investments by internationals, multinationals, happen more in countries with more open environments, regardless of the size of their economies. We control for that. Oops, did I skip one? Oh, on here, I think also high-tech information sector does better. We also did some controls for, does it hurt the entertainment industry? Does it hurt publishing industry? And we don't find any negative relationships there. And then we also find that access to knowledge and the production of knowledge benefits through fair use defined as more open exceptions. More open exceptions help the receipt and production of scholarly output. Okay, so that's the 2 points, right? That fair use defined as more open exceptions promote your ability to meet human rights obligations. Fair use defined as more open exceptions promotes trade. We use the proxy of foreign direct of multinational investment and economic development and scholarly output. So it seems a natural place that we should be addressing these things within trade agreements. So the question is, are we? So first step, Danielle and some of our other friends, when we first came out of that first meeting of the organization of this group, looked at the threats. And the first threat is that within international copyright law, and I don't have the text here, I'm sorry, but there's something called the three-step test. And the most important part of the three-step test says essentially you can only have limitations and exceptions to copyright if they're specific. And so that's the interpretive question. Well, what does that mean? Does that mean you can't have what Sean Flynn just told me here, like more open exceptions that apply to any purpose and to any work and that he thinks is so great? And so we commissioned a study that says, no, that's definitely not what it means. But you can use your human rights tools as well in that. And you can say, well, how should you view that term when you're faced with that term and you have human rights duties to promote access to education and cultural materials? How do you use those to kind of interpret that term? Does it mean that your law can be general and that you can apply that specifically case by case, which is what we would say? Or do you go the other way and say, well, what that means is you can't have laws of general application. You actually have to be specific in the law. So that's one of the things that you can do within trade agreement texts, and actually we've got some examples of that, is you affirmatively protect, or here I say respect, the right to fair use. So for countries that want to do it, you make sure that the international agreement does not impinge on their ability to adopt more open limitations and exceptions. So the US-Korea agreement has a footnote, and this is a footnote to the three-step test, and it makes clear that each party may adopt limitations and exceptions for fair use. So they don't define fair use there. But I think what it means is fair use in the OFG term. Like you may use open, flexible, general exceptions within your law and not be challenged under that free trade agreement. That's the only one that has it, though. It happened once, right? WCT agreed statements, contracting parties may carry forward and appropriately extend is also language that is described as, being intended to protect either fair use OFG or fair use number one, just the ability to have different kinds of fair use rights, even if those things are more specific. So I'm using respect here in the human rights sense. One of the duties is to respect countries' ability, not have an international agreement that withdraws countries' abilities to have fair use rights. And that's one of the things that you can do in a trade agreement. And then you can move down in the second category is to promote. So here, and this would be more the duty to fulfill, international law can itself create obligations or incentives for countries to move further, to actually adopt fair use rights. And the most complete of these is in the TPP, the idea that countries must promote balance, or in the EU InfoSoc directive, which actually has a specific exception that you have to have. You have to allow temporary acts of copying. Okay, so kind of the conclusion and the way forward that I'm not going to get into here, but is we should be splicing these things together. If you were going to do an ideal agreement, and we've developed some models that we're promoting with NAFTA and other agreements, you should do them all. You should include all of these things within each trade agreement, and there might be a copyright balance section or something that would do this. And so I'm going to end with this notice that these discussions are going to continue to take place on these and a bunch of other issues at this big Congress. So the Global Congress on IP and the Public Interest is going to be held at our school in September. And if you're interested, that's the place to go to keep intact. And we'll be presenting actual applications sometimes next week or the week after. So thank you very much.